Okay, this is the last part, um, and it will be shorter, I think, than the other parts. All right, so I want to say a few things about trade and environment because this has to start being quite an important issue. Of course, the environment obviously matters a great deal to us, but also it does have lots of interesting trade implications. Is trade good for the environment? Is trade bad for the environment? Well, of course, it can. It can be both good and bad. It depends naturally on what is being traded. In addition, um, in determining whether trade law is good for the environment, we need to ask a number of interesting questions. One of them is, well, if there are environmental problems in relation to trade, does international trade law provide some steps to be taken to correct the problem? And well, of course, the answer is yes. The issue of whether trade law goes far enough is a matter for some debate. And I would ask you to think about it, but I'm certainly not going to offer you any answers. You need to sort of come to your own conclusions. One of the most important safeguards, which I guess is implied in the name, general exceptions, is GATT Article 20. And now GATT Article 20 is a very important part of GATT because of the general exceptions, but it also has a couple of provisions that are relevant to the environment. Right? So let's look at the text here. Subject to the requirement that such measures are not applied in a manner which would constitute a means of arbitrary or unjustifiable discrimination between countries where the same conditions prevail, or a disguised restriction on international trade. Nothing is this agreement, which of course is GATT, shall be construed to prevent the adoption or enforcement by any contracting party of measures. There's a whole list of these. I'm just going to give you B and G because they are the most relevant to the matter at hand. Be necessary to protect human, animal, or plant life or health. G, measures relating to the conservation of exhaustible natural resources, if such measures are made effective in conjunction with restrictions on domestic production or consumption. If there aren't such restrictions, then clearly there is at least a very national treatment issue, isn't there? So, in a sense, there is broad scope to bring in measures, necessary measures to protect life or health, and also measures to conserve natural resources. Of course, there is one completely separate trade agreement which is intended to be trade restrictive, and this is the CITES Convention, or the Convention on the International Trade in Endangered Species. And the CITES, this treaty, has basically two lists. There are endangered species where there must be absolutely no trade at all, complete trade bans. And there's also a list of species where trade is restrained, is controlled, but not completely stopped. So clearly the fact that this convention was deemed necessary is a sign that, of course, trade sometimes can be harmful for species, and that we need sometimes to restrain it anyway. So you wouldn't expect the World Trade Organization to actually counter this, or to bring in measures that would make that convention unworkable. So let's look at briefly at two disputes. Well, these are not single disputes. Both of these cases actually ran on for quite a few years. So But they are very interesting. And I'm not going to go into any details, but if you are interested, you can really go into the details, and they are quite fascinating. Let's look at first at tuna, dolphin. And this was starts off as a complaint by Mexico against the United States. Oh, I need to actually correct that. Dolphin safe. It should be dolphin safe. I'll come to that anyway. In 1972, the United States passed a law called the Marine Mammal Protection Act. And so the act, what does the act do? Actually, when I do the slides, I'll correct the spelling, a couple of typos here. The act was in response to, among other things, to the problem whereby where tuna fish is caught, well, dolphins often swim very near tuna, and as a consequence, to catch tuna, catching tuna sadly leaves a lot of dead dolphins, and we don't eat dolphins generally. So this is rather rather sad, particularly as most of us, like dolphins. It's very good-natured mammals, sea mammals, for at least for humans. So there's a label, eco-labeling, ecological labeling, which I've mentioned before, but there are labels on products, which signal that the products are produced in a way that is either friendly to the environment or is good for animal welfare. So in 1990, most tuna companies in the United States, tuna, not tune, but tuna, companies adopt a dolphin safe label. And eventually that becomes a situation, although it is a voluntary labeling scheme, what happens is that in time, the whole US tuna fleet is dolphin safe. And then the act then bans the import of tuna caught by countries with non-compliant practices. So dolphin safe, so all the tuna caught in the United States by the US national fleet is dolphin safe, and it carries that that label. And essentially, and what happens, of course, is that there are no tuna sold in America that are not dolphin safe, and then no tuna sold in America that can be anything other than dolphin safe. Now, is this allowed under the rules under WTO law? And well, this was not just an Article 20 issue, but it was a TBT issue, and we've already seen TBT Article 2.1, so was United States right? Well, in principle, yes, and this what the United States did was allowed under GATT Article 20B. So let's go back to B. Oops. B, necessary to protect human, animal, or plant life or health. So in this case, animal welfare, right? So it was allowable under Article 20, but nonetheless, it was the United States failed under TBT Article 2.1. Why? Because it imposed stricter verification requirements on Mexico than other tropical Pacific countries. So it was actually sort of discriminatory against Mexico, and therefore what the United States needed to do was to change, was to equalize those verification requirements so that Mexico was treated the same as every other country. So see, what can happen here is that everything is right except one thing. It is, in one way or another, it is discriminatory, and it was Mexico that made the complaint. So they won. So the United States then had to go and change their law so that Mexico was treated the same as everybody else. So that was a TBT issue. Shrimp turtle. Now, shrimp turtle was the subject of 2 appellate body reports. Now, what's shrimp turtle about? Again, it involves the catching of seafood that inadvertently causes the death of other living things. In this case, it was turtles. Now, there is a way of catching shrimps without endangering turtles. And a technology was invented called the turtle excluder device. And the turtle excluder device enables the turtle to escape so that it swims away freely and turtles are safe when catching of shrimp. Now, the United States required this of American shrimp fishers, but then they required importers to have in their country regulations to control incidental turtle deaths, and actually required the use by shrimp fishermen, women, of turtle excluder devices. This was controversial, is that because it sounds like the United States is requiring other countries to adopt its own regulations, and that raised sovereignty issues. Now, the panel said that this embargo of shrimp imported from countries not having these regulations fell outside the ambit of Article 20, basically took the view that the integrity of the patent system must come, of the trade system must come first, and we shouldn't so easily let that go in providing accommodation of United States requirements of other countries. This was reversed by the appellate body, and basically the appellate body had adopted, let's say, a more permissive view towards the use of Article 20G. Article 20G, which is, and not only this, but the appellate body actually used multilateral environmental agreements to interpret exhaustible natural resources as also including living resources. Right? So natural resources, up to that point, there's the question of, well, are exhaustible natural resources, what do we mean here? Do we mean by mineral resources? Right? So it might be possible to interpret exhaustible natural resources as mineral resources only, but actually under multilateral environmental law, which the appellate body chose, didn't have to, but chose to take into consideration, well, turtles are exhaustible natural resources. Well, clearly they are exhaustible because there are certain turtle species that are actually endangered. So on that ground, you might say, well, the United States won. Well, not quite. The problem is that it was discriminatory against some countries. Well, again, no. So against some Asian countries, because in the Western Hemisphere, the countries near the United States were receiving technical and financial assistance, and they're also getting transition periods in order to get their regulations in shape and to actually provide these turtle excluder devices. And so the difficulty is here that certain Asian countries, Thailand and others, that were exporting shrimp to the United States, they were unfairly treated because they were not given the same technical and financial assistance as countries in the Western Hemisphere were getting. And so therefore it was arbitrary and unjustifiable discrimination. Well, 3 years later, the appellate body sat again to decide about this. The difference was the United States had basically provided the same assistance as they were giving to Western Hemisphere countries to other exporters of shrimp. And once that discrimination was taken away, the United States was therefore able to show that it was not discriminatory, and therefore US practice as revised by 2001 was seen to be compliant with WTO law. So what do these two cases show? Well, they show that there is quite broad scope to bring in environmental measures to protect natural resources, including living resources, and also endangered species, and to protect the welfare of animals. And trade can be restricted for those objectives. The point is that when you look at Article 20 and try to apply the sub-paragraphs of Article 20, you must forget the chapeau, the bit at the top of Article 20, which does require that there be no discrimination. So as long as you're not discriminatory, there seems to be a fairly wide scope to apply these kinds of trade restrictive environmental measures. Whether they go far enough is a matter for, obviously, for further discussion and debate, something again to think about. And this point I make is also reinforced by a statement for the panel in the China Rare Earth case, again, without going to the facts of the case, although I have mentioned it before. An interpretation of WTO law that resulted in sovereign states being legally prevented from taking measures that are necessary to protect the environment or human, animal, or plant life or health would likely be inconsistent with the objective and purpose of the WTO agreement. So if you look back at the WTO agreement, the preamble of the WTO agreement, that reinforces, according to the panel here, that reinforces the view that you are given fairly broad scope to restrict trade for environmental protection or to protect life, whether human, animal, or plant. Okay, we're getting towards the end now, and I just wanted to talk a little bit about what has happened in the last 20 or so years. Now, I've talked previously about trade rounds, numerous trade rounds that have taken place over the years, mostly under GATT. Now, in the year 2001, there took place the ministerial conference, met and held their meeting in Doha in Qatar. Now, at the time, there were a few things going on. One issue was that there was a problem with the TRIPS, or concern about the TRIPS agreement in the context of a massive health crisis facing many developing countries, the mass infection, or almost like a pandemic of HIV/AIDS, as well as continuing problems with malaria and tuberculosis, among other diseases, but particularly HIV/AIDS. And there was a concern that the patents part of the TRIPS agreement needed to be perhaps reorientated in a way to assist developing countries in improving access to medicines, essential medicines, and for these infectious diseases. In addition to which, there was a big concern among many developing countries that implementing WTO law was a very difficult and complex thing that couldn't be done in a short period of time, and that therefore it was important to accommodate particularly the concerns of these developing countries. I mean, WTO law is obviously hugely complicated, and it's a big body of law, and so there was a need felt to accommodate developing countries' wishes for the trade round to address their particular implementation related issues and concerns. And so it was decided in Doha that there would be a new trade round. which was labeled the Doha Development Round. Now, for various reasons, this trade round has not been particularly successful. It's not been a complete failure, but neither has it been particularly successful. Countries haven't been very unified, and so there have been agreements, there have been things agreed, but a lot of things haven't actually been agreed. For example, the European Union wanted to promote certain issues related to things like investment and competition, and as well as trade facilitation. So investment and competition, these issues, there hasn't been much of an advance on those. But on the other hand, trade facilitation, there is now a trade facilitation agreement. The trade facilitation agreement is meant to really improve administrative procedures for goods crossing national boundaries. It came into force in 2017, and I think generally considered it's fairly uncontroversial and a good thing. It's a good thing for checks on goods, tariffs to be paid on goods crossing borders in as fast a way as possible, speeding up trade across national boundaries. Nobody really disagrees that this is a good thing. In addition to which, there was an amendment of the trust agreement which took place in 2005. I mentioned it before, but the amendment was intended to improve the opportunity, or to expand the opportunity for compulsory licensing of essential medicines and other important drugs in countries which do not have the capacity to manufacture these medicines in and around the country. And it means that Articles 31F and H of the TRIPS agreement can be waived, can be basically ignored for developing countries that are, and these developed countries that seek to apply the measures that are made available so that compulsory licensing can, for medicines to be exported, is now possible, and also the remuneration to patent holders must only be paid by the country that is exporting to you and not by the importer country, which is assumed to be a much poorer country. So has the WTO been a success, and is it fair? These are two different questions here. Has it been a success, and is it fair? It's been, you could say it's been a success in the sense that developing countries' participation in trade has increased overall, and that trade has expanded. And I suppose you could say that for much of the time, the world has become a more prosperous place overall, despite some shocks, such as in the late 2000s, with plus also, well, the shock that we're having now is going to lead to a contraction, unfortunately, as well. But overall, there has been an increase in trade. A lot of very poor countries have become less poor, which I think is incredibly important, but obviously. However, a lot of that increased participation in trade has come from, a lot of it has come from China and East Asia, and hasn't necessarily happened elsewhere in the world. So clearly there needs to be more participation from Africa, from Latin America, and other parts of the developing world too. So not everybody has participated in this expansion of trade. Of course, it's important to note that correlation and causation are not necessarily the same thing. So we don't know how much of this expanded trade is because of the WTO, or how much it would have happened anyway, but we're not able to really know this. So is trade necessary for development? So that's interesting questions that we could have had for discussion, but we can't really do this. But these are good questions. is trade necessary for development? I mean, it would seem to be yes, but is it always good for development? Well, we looked at some of the arguments at the beginning to suggest that sometimes uncontrolled trade may not be a good thing. So when is it good, when is it not? In what ways might global free trade rules promote development? In what ways might they actually form a barrier? In what ways might they actually get in the way? Are there, I mean, you might say the agriculture still isn't really freeing up trade in the interest of exporter or countries, for example. You know, agriculture, it still, you know, enables rich countries still to, to protect their markets more than they should. Are the WTO rules equally fair for all members? How level is the playing field, right? On the one hand, a small country like Antigua can, in a dispute, win over the United States, a much bigger, more powerful country, right? So each country has equal rights, but in practice, right? What really happens? Does the dispute settlement system really create a level playing field? Formally, yes. Practically, perhaps not. If the United States says, or the EU says, look, we're not going to implement this panel report, this adverse panel report, what if Antigua says, what if another small country says, well, we're not going to, we lost, okay, well, we're not going to implement the panel report because we don't think it's of interest and we're willing to just carry on without doing it. Well, their freedom to do that is probably going to be much more constrained, especially if they've won the dispute over a much more powerful country. They're more likely to retaliate or to seek authorization to retaliate and actually practice that retaliation. So we still have some way to go, perhaps. Back to these sorts of questions, these are talking points, and perhaps when you have some time, you can spend some time going through these questions by yourselves and asking yourselves, are these genuine criticisms? How would you respond to these criticisms? Ask yourselves these sorts of questions. So a few final points. What do we know, or what do we think we know? Well, not everybody gains from global trade rules. I think you can say that that's true. Even in the best case, some will gain more than others. In the worst case, and probably in reality, some will lose. These may be countries, business sectors, there may be consumers, but there'll be winners as well as losers. So you adopt the winner's perspective, in which case everything is wonderful, or do you adopt the loser's perspective and say, no, nothing's good here. You know, if we're not gaining, then if we're losing out, then this must be a disaster for us. And if enough people feel that way, you're going to get a lot of opposition to the global trade system, which you do have, you know, in the United States, without singling out a particular country for criticism. The United States government seems to be pulling back and saying, well, we don't actually, we're not sure we like these rules anymore, even though we agreed to them 25 years ago. Well, welfare economists have a number of ways to seek to approach this question, right? So, and perhaps I'll just say something about the Kaldor-Hicks criteria. The criteria of optimality seems to me so incredibly abstract that I don't, that I struggle to find use for myself, although other economists think it's rather brilliant. We leave them to, or to you to yeah, think about whether you think it's actually useful. Well, the Kaldor-Hicks, named after Nicholas Kaldor and John Hicks, I think they both won Nobel Prizes for economics quite a long time ago. This is what they say: well, any change within an economy that favors some individuals at the expense of others will be an improvement if the gains to the winners exceed the losses to the losers. Right, that winners could actually compensate losers, so everybody would be better off. So So let's say, well, I talked about Korea before. So if all the people who benefit from trade law, that would include perhaps most city people who have jobs, they may say, well, trade law is good for us. So if we could pay the farmers, right, enough to say, the farmers say, okay, we are as good as we were before, or we're actually better off now, then everyone's happy. But of course, the thing is that never happens. No one actually does compensate the farmers or ones who lose. So they go away feeling like, it's not working for us, it's bad for us. So in theory, this idea is quite powerful. If the winners could actually compensate the losers using their gains or some of their gains for that, then we have an efficient outcome. And that's overall good. Right? Similarly, there's utilitarian philosophy, which says, the greatest good for the greatest number of people. Again, perhaps somewhat vague, but it can form the basis of a similar type of calculation. But again, it's hard to say. Plus, there are non-economic values taken into account here. And I've talked about this before, non-economic values. Sometimes people say, well, it's not about the money. It's not about material gains. I mean, for example, in my own country, there are people who talk about Britain leaving the European Union, Brexit, and they say, well, okay, it might make us worse off. It will make us worse off, but we don't mind. I have to say, I don't really agree with that position, but I'd rather we stay. But yeah, they say, well, we don't mind because there are things that are more important to us. So the single market, the European Customs Union, yes, I can see why they might be objectively good things, but actually I'm willing to walk away from this because I would rather be worse off but not be a member of the European Union. So some people do think that way and they vote accordingly. But also you could say that WTO law does reinforce existing forms of protectionism or even creates new forms of protectionism. For example, an American, I think he's now retired, a retired professor at Columbia University in New York, basically says the TRIPS agreement is creating a new form of protectionism. Now he speaks on the basis of a free trade. He's a complete believer in free trade, right? And he argues that TRIPS is anti-free trade. It is a form of protectionism. Right? It's an interesting perspective. Does WTO law reinforce existing forms of protectionism? Well, that is an accusation that might be made by the Australians against the Europeans in relation to agriculture. The Americans might also use that to accuse the Europeans with geographical indications and the overextensive inclusion of goods protected under the scheme, which they would say goes much, much too far. It is anti-competitive. It's a form of protectionism that shouldn't, that trade law shouldn't allow. So protectionism itself is an interesting term, which does require some sort of investigation. Just as free trade is an interesting term. Free trade, freeing up trade, doesn't necessarily mean unregulated trade. In fact, it might require trade to be regulated to make it free. It's an interesting kind of paradox. It seems as if I am putting together opposite statements and saying, actually, it's not opposite, it's actually consistent. And in fact, I think it actually is. Right? So, is WTO law too lax? Is it too lax about requiring reduction of tariffs? Is it too weak in relation to getting rid of unfair or unreasonable or arbitrary non-tariff barriers? These are things that you might want to think about, right? Again, it would be nice to have had a discussion about this, but it's not something that we can do. Right, so what, I'm going to finish now with WTO law. I will be giving you some essay questions to do. I'm fully aware that you're missing out from the classes in the sense that we're not able to discuss this together, but you can email me and you're very welcome to do so. I've tried to provide as much material as I can online so that you don't, without having to leave your home, you can, as long as you have a good internet connection, you can get access to these. I know that SSRN, or the Social Science Network, is a fantastic source of almost entirely open access journal articles by very well-known authors, including top trade law academics, which you should look at. The WT website, I think, is a fantastic resource itself. So that's another great source. Whatever people think about the WTO, nobody says it's a terrible website. You can find out all the dispute settlement report, all the appellate body reports. So it's a wonderful resource. You can download all the relevant agreements if you haven't done it already. And hopefully you'll find these slides important. I'm going to correct a couple of typographical errors and move around a couple of slides, and I will convert them to PDF, and they will also be available to you as well. So you can have a look through in your own time, and of course you have these, you have me talking and talking and talking and talking. Hopefully some of what I'm saying is useful. All right, but the slides are no substitute for doing your own independent reading. I'm just going to leave you with a few slides that I often use when I do the Chicago Kent teaching. If it's a new class and you've only recently started, and maybe that may not be true in your case. You may be actually well through the year and getting towards the end. In which case, I'm not sure if you necessarily find it all that useful, but you may want to have a quick look through these. I do teach academic writing, and so yeah, I want to stress the importance of economy in writing, of keeping it short, saying a lot with a little. Right? Blaise Pascal, the French philosopher of the 17th century, said, "I've made this letter longer than usual only because I have not had the time to make it short." Being brief is a real skill, and the better that you get at it, the better writer that you actually are. And it's how we judge. I want to stress independent critical thinking. We want to know what you think, right? Not what somebody else thinks, right? And a few common errors in preparation that you might wish to avoid. Common errors in writing. Do get to the point. Make every word count. I often say this to students, my own experience. When I was doing my master's degree many years ago, and we were given a 3,000 word limit for an essay, and I thought, well, this sounds this difficult, because how do I write 3,000 words on a subject I don't feel I know that much? Well, actually, it's quite easy to write 3,000 words, but are they good words? Is it good text? Well, I ended up writing more than 3,000 words, so I thought, oh no, now I have to lose about 200 words to get down to 2,999. So I did that, and then I thought, oh God, I forgot to say something about this. So now I've got to go over again. And now where do I lose, 30 words? So I've got to lose 30 words, take those out, and I thought, oh, I've got something else. And I go over again, over the 3,000. And you see what's going on here is that as you do this, the quality of your work gets better, right? A word limit is a wonderful way to make you a better writer. So keep to that word limit, say as much as you possibly can within the limitations of a word maximum. That's really important to say. some of the obvious points that you would know anyway, but here they are if you want to have a little browse through them. Yeah, read your work again and again and again until you're absolutely satisfied with it. All right. So thank you very much for listening. It can't be easy, and I'm so sorry that I'm not there with you. I do enjoy teaching on the Chicago Kent program, and I'm much better at doing that than I am talking to myself in front of my laptop computer. But I do hope it's been useful. I know, of course, that you're not getting the usual full weekend, and for those students, they have an advantage. So when you do get your questions and you think about them, do ask me questions. You can email me when you like. I'll do my best to answer you within 24 hours. And so I wish you luck, and I hope everything goes well. I hope everyone stays safe and healthy, and you get to do that study semester in Chicago. And I wish you all the best for the future. So from me, goodbye and good luck and stay well.